Hi everyone, thanks for being on time. Okay, but in the meantime, while we wait for other people to turn up, I'm just going to introduce our panel for today. So we have with us Aloysius. Aloysius is the CEO and founder of Sage Mediation. And then to my right, I have Sharon. Sharon is actually a partner at Withers Katawong. And then I also have James with me. James is actually a professor at Rikyo University in Tokyo. So you have a quite diverse panel today. So one's a mediator, another one's advocate, and then we have an academic, James. So without further ado, I'm going to pass the floor over to Aloysius, and she's just going to take it away.
Good day to everybody. Thanks for joining us today. And thanks for the introduction, Jessica. I won't take up too much time introducing all of us again, but what I want to do is to give everybody a sense of what is going to happen in the next nearly 2 hours, and what we want to do to make sure that this proves to be useful. So we are using a fictitious simulation scenario. This is not one of your competition scenarios. I have also noticed that in the audience, there's quite a few fellow assessors, judges in the midst, which gives me a lot of stress, but thank you for being here. What we are going to do in this scenario is that we will be doing a bit of demonstration, but I think as we discussed whether we should put in negative injects as well and positive injects, I think the truth is that we will be playing our part, and there will be some things which we do deliberately, which some of you might find slightly questionable, right? And there will be some things which you do, and maybe you might say, wow, that's great. Hopefully more of the latter than the earlier. In any case, the idea for today is to have a bit of a discussion with everybody, assessors as well as participants. So as you see things which are happening, if you have comments that you would like to make, you can make them in the private chat. If there's questions that you want to ask, you can make them in the private chat. My teammate Samantha is also going to be making a running commentary as we carry on the simulation. For the nature of today's simulation is a corporate dispute. It's a dispute between two company shareholders, and there is alleged minority oppression. They are represented today in the dispute by counsel only. The clients themselves are not present. So counsels will take the lead in the negotiation. How today's exchange is going to go, we will take a few pauses as we do the demo. So I'm going to do my introductions as a mediator, and then one of the counsels will speak, and after he has spoken, we might take a pause there, and then we will let the other, and do a bit of discussion. We will let the other counsel speak after that, and then we try to resolve the problem thereafter, and we might take a pause in the middle there as well before we carry on with the demonstration, and then we end the whole session of the demonstration. And then we hopefully have about 30 minutes to 45 minutes of time where we just have an open discussion with everyone, right? So you can ask questions of Sharon and James, you can ask questions of other assessors who are here. Don't ask, only if you have easy questions you ask me. Any other hard questions you ask everybody else. That is the ground rule that we operate by. When you want to ask any questions, please show your video so that I don't hear voices coming out from my walls, and that makes me worried. All right, so Sharon, James, any other points you think we should let the audience know?
I think you covered it. Yeah, I mean, James and I have decided to input some negative behavior so as to test Aloysius' skill as a mediator. I mean, this happens quite often during a real life situation. So it is not that we are being deliberate about it, but it's a learning point for everyone. So that's the whole purpose of the demonstration.
Okay, and I'm going to try to run this. I mean, I'm trying to be funny about it now, but I will try to run this as seriously as I can. Even though I know James and Sharon are going to deliberately make my life miserable, right? And I promise them we will use American presidential debate rules, and I'll just mute everybody if they really make me cry. Anyway, so without further ado, let's start the mediation demonstration. Right, so as Jessica has said, if for those of you who have access to it and you can stop your video, that will help you to concentrate. Otherwise, it's fine as well. We will carry on as is. Okay, so well, very good afternoon to the both of you. Thank you for coming for the mediation today. Well, just want to have a quick check with the both of you in terms of your mediation experience. I get it, Sharon, that you are from Singapore. James, have you had mediations in Singapore before?
I've not had mediations in Singapore. I've had mediations in Japan before the courts, so I'm familiar with that practice.
Right, and I have some familiarity with how things are being done in Japan. But I do note that there is some difference, and this is the first case that the both of you are doing with Sage. Maybe if you give me 3 minutes, I will just do a quick explanation of how things are likely to flow for today with Sage. All right, so I think as both of you are probably already familiar, my role as a mediator is really here to try and listen to what you've got to say on behalf of your clients. I understand they cannot make it here today. The instructions that we are going by is that I will not play an evaluative role in this, but I will certainly be using my experience as a mediator to really give different perspectives and ask some of the questions which I think will help us to find more constructive ways to get a problem resolved for your clients. And how I like to have the process flow is to take some time to listen to each side first, and thereafter we try and quickly map out exactly what we have to discuss, set an agenda for it. It is accepted practice here, and tell me if you're not comfortable for us to have private meetings. So I might, if necessary, ask to meet with each of you privately. There might be more than one of these private meetings, and then we will come back together, hopefully with new light on how we can get the matter resolved. And to get the matter resolved, what we will do is to write down the terms so that it's binding as a contract, and we then have the option as well under the Singapore Convention on, since this is going to be under the jurisdiction of Singapore, which has ratified the convention, to get it enforced, right? So really, in terms of a process, quite straightforward and simple. Is that okay for the both of you?
Yes.
Yes.
Fantastic. So really, before we start, and really for my comfort and the comfort of everybody here, I just need to do a few procedural checks. And the first thing is, because your clients are not here, just want to confirm that you guys have the authority to negotiate and to sign on their behalf if we can get a settlement.
Yes, I do.
Yes,
Great.
I do.
Fantastic. What I often encounter in such mediations is that from time to time, I understand that you've been given some mandate. In the event that we have to look at solutions beyond the current mandate, are you guys able to contact your client?
I am indeed, yes.
Yes.
Very good. Thanks. This is encouraging for me, and it's a good start. I think the other small point, and you guys will be familiar, is that just want to say again, everything that we say here is going to be confidential. I do hope we can get the matter settled, but in the event that we can't, it is without prejudice. Okay, and I don't think I need to explain too much about that, since we're dealing with counsels here. The last thing that I would like to really reiterate is, I mean, I guess you guys are agents here, and it might not be, you might not feel as emotionally connected to the dispute as your clients do, but I have also not been surprised that from time to time, when we hear things from the other side that are different from what we have heard, it can make us frustrated. I urge you to exercise that level of professionalism and courtesy. I promise you that if there's anything that you hear which is not consistent with what you know, there will be a chance for these differences and disagreements to be addressed. Right? So let's exercise that level of respect for each other when one person is speaking. All good.
Understood.
So if there is no questions for me at this juncture on how things will flow and your expected roles, shall we start with the mediation then?
Sure.
Wonderful. So as you may know, there's no strict rule about who to start first when it's mediation. Is there any one of you who wishes to share your client's perspective first?
With the understanding this is not a litigation or an arbitration, since the other party has made legal claims, it might make sense if she start and then I can respond to those claims.
Sharon, is that okay with you?
Actually, I would prefer the requesting party to start first, since James' client is the requesting party. They should start and put forth what they wish to achieve out of this mediation.
I'm very happy to see this courtesy being exchanged between the two of you. In which case, maybe James, I mean, perhaps since your client was the one that requested for the mediation, can I trouble you to let me know how your client feels about what had happened and this decision to go for mediation? What is the desired outcome from today's discussion? Yep.
Okay, sure. Thank you very much. I am happy to be here. I'm glad to have the opportunity to speak on behalf of my client. I think what my client has communicated to me, if it were to be summed up in one word, it would be a feeling of ingratitude on the part of party B. I think that my client has gone to extreme measures to try and promote the career and the opportunities for party B, in particular by bringing this relatively young, new associate with the firm up as a director and even as the deputy CEO in the company, to bring party B into ownership, company ownership of 5% stake, no less, and to even publicize amongst the other members of the company that this is the person that my client wanted to be his replacement in the future. So I feel like he's invested a lot of time and confidence and trust in party B. Now, unfortunately, that has not been reciprocated. Speaking as an attorney now, if I were to give legal terms to what has happened, I would begin with breach of fiduciary duty. Now, counsel for party B will be familiar with that term because that's the term that she used in the letter that she wrote to my client. But I think it's certainly true of the behavior of party B. From the position of deputy CEO, party B has undertaken to terminate an extremely important relationship, long-lasting relationship for the company, for the private equity company. And in so doing, did not go to the trouble to advise the CEO of the company or to seek approval from any members of the board of directors. Now, under any employee contract, under any agreement about structure and hierarchy, that's the kind of decision that would need to be taken by consensus. And in this case, there was no attempt even to try and build consensus. And that's just really one of the many things that has happened that has brought us here to the mediation today. There has been a breakdown of communications with clients, which is extremely troubling. The party B seems to want to triage based on what he thinks is best in terms of whether to return calls and emails from clients. And this is extremely destructive, of course, for the company. Party B has also acted out during meetings. He seemed in the past to be reliable. He seemed to encourage new thought, but since being given this position, thanks to my client, he has been losing his temper in meetings. So all of this leaves little doubt to the fact that there's a breach of fiduciary duty. So I think that's an important legal point. Now, I know we're here not only to talk about law. With my familiarity with the Japanese court system, I understand that it's very important to explore other interests. My client, unfortunately, couldn't be here. I know he would very much like to himself give voice to his interests, but I'll try and do my best to communicate those interests. But before I leave the legal point, and before we turn to matters that are perhaps more constructive, another legal term that I might give to this situation is a frivolous lawsuit. There has been a lawsuit brought against my client on shaky grounds, to say the very least. And this has put my client in a very difficult position within the company. And as you will have known, as you will know from having looked at the record, there have been threats made based on an allegation that there was an improper relationship between my client and a long-standing client of the company. In particular, the allegation was that there was latitude being given to the client not to top up its capital for investments in the future, and that as a result of these late top-ups, with the application of interest, this has caused the company some money. Now, setting aside the fact that this is one of the firm's most important clients, and that we have relied on the client for years and years to generate revenue, but also to bring us business, particularly from China, where the client is extremely well connected. Setting that to the side, when looking at the amount of money lost in interest, which we suggest has been grossly inflated by counsel for Party B, that pales in comparison to the money that stands to be lost now, having lost one of the firm's very best clients. So we are ready to move forward with a claim for a frivolous lawsuit if this does become, in fact, a lawsuit. And one other legal matter that I'll put on the table before turning to more constructive things is that there's also a consideration about defamation. Because in the letter that counsel for Party B wrote to my client, there was an allegation that there were kickbacks. And Party B has shown in the past that they don't have any clear sense of loyalty, in particular by going into a meeting of the directors and making accusations that were untrue of my client. And so the concern is that if this letter becomes public, then that would reflect badly on my client, and we would be adding claim of defamation. Now, having said all that, I'd like to remind everyone that it was in fact our idea to come to mediation. We would prefer not to move forward with this legal course. We feel like there could be a more constructive solution coming out of our meeting today, and we're very hopeful. We do have certain common interests. If we go back before things turned south in the relationship, my client was very happy with the performance of Party B. In fact, that's what led to this very generous offer of ownership in the company and to the position as the deputy CEO. So there is an important relationship there, that I think my client does not want to simply turn his back on easily. Because this has come to us as a lawsuit, we are obligated to respond in kind, but we're happy that Party B has agreed to come and mediate, and we see that there could be scope for a solution that is better for everyone than going forward in court. That's all I have to say for the moment.
Thank you, James, and that was a helpful statement, well organized, and gave me a good understanding of what your client is after. Maybe Sharon, if you allow me, before I invite you to share your client's perspective, let me just make very sure that I've caught much of what James is trying to convey to us. James, if there's anything which I'm summarizing wrongly, please do let me know so that we are all sure that we're all on the same page on what your client is concerned about, right? So I think what was good was that you ended your statement with an emphasis on what your client is interested in coming for this mediation, and what your client is interested in is an amicable settlement, because he is himself appreciative of B's contributions to the company. And perhaps, as you had started this opening statement, what has been distressing for your client was appreciation. You know, that after B joined, the way you had explained it was that B had been an associate, but he had done well. And your client, as the CEO of the private equity firm, eventually recognized this and promoted him to become a deputy CEO, and even publicly announced that B would probably be the one that is taking over the company from him. The concerns that your client now has is that after the promotion, there have been certain incidents, and one was the termination of a long-standing relationship with a valuable client. And from what your client knows, this termination was not. It didn't follow the usual practice where there would at least have been a discussion with the board first. It seemed to have been a decision which B made on his own. And
I have to say, I think that's absolutely right, but I think it's putting it very lightly.
Right.
I think the action taken by Party B to basically usurp the board of directors and the CEO of the company is something more serious than just something that's uncommon or not in accordance with regular protocol.
All right. So he could have consulted with the board first, and at least with your client first, which B had not done. And this client was somebody, as you said, who was important because he brought in quite a lot of business for the company, right? In addition to his own business, because I think what you said was he has a good network, particularly in the China market.
Right.
And of course, in addition to this, there were other behaviors involving B's communication with clients and behavior at the meetings. The reliability and professionalism which your client had otherwise remembered him for, that had led to his promotion. Your client just didn't see so much after the promotion. So that is one aspect that your client is concerned about. The second part was that there has been a lawsuit that has been started against your client, which again put your client in an uncomfortable situation, because there have been allegations made that there was improper relations between your client and this client whose contract the company has been terminated. And
just again, I agree that's exactly right, but you said uncomfortable position. I mean, I think of this more as a complete betrayal. He invested in the future of this young, promising associate, and in the end, the associate tried to basically start a coup against him with the other members of the board. So just you're exactly right, but I just want to be careful about my client's position.
And thank you for clarifying this, James. I think this feelings that your client has about loyalty and mutual trust, we hear loud and clear. And again, it is this element of trust which is really, I think you have said it many times, it is a key point for your clients, right? And I guess what you had said is that the loss that the company potentially suffers from the loss of this key client is actually going to be quite significant compared to the loss which B has claimed keeping this client has cost the company. And the last point, of course, is this idea of reputation. With all the allegations that have been made, your client is concerned about the impact that those allegations have had on his reputation, and it is something which he hopes some closure and can be achieved at this mediation. Did I miss anything which your client is concerned about, which I should have paid better attention to?
No, you've covered all the main points. Thank you.
Thank you so much. And I think with that, Sharon, thanks for your patience and thanks for listening. I'm going to, if you would like to tell me really what is it that B is concerned about? And let's pause there. Okay, so any questions, comments from the audience about what you guys have seen so far? Feel free to ask difficult questions of James and Sharon.
Okay, so before we take in more questions, there is actually a question from Aishwarya. I'm sorry if I pronounce your name wrong. So Aishwarya said, while confirming our authority, do we specify that in the event a proposal needs the consent of the board of directors or the CEO, we prefer to go back to the opposing counsel after consultation in the next session, or is it better to immediately consult and consider the proposal on the spot? So I'm just jumping in here because I think this is a question that is better suited for the organizing team to answer rather than for our panel today. So the thing is, when confirming your authority, the best people who can give you authority is actually your clients. And for the IMSG rounds, it has been drafted in such a way that you are all advocates and your clients are not present with you. And there is nobody you can call during the 90 minutes of the rounds to actually consult immediately. So what I would recommend is actually you say something that if there is a proposal and you need further consent, so just say that you will need to get consent from whoever that is going to be giving you consent, and then just carry on with the mediation.
Aishwarya, does that satisfy you? Yeah. I mean, I'm also, let's take it from a realistic perspective too. Sharon, if this happens in a real mediation, what is the usual practice?
Usually at the opening stage, you would have some in principle consent, mandate from the clients to disclose certain information. So I don't think you have to be too worried at that juncture, because it's not really at a stage where you need to decide on what are the terms to settle. So at that point in time, you would have some basic mandate from the client to act on that mandate to proceed with the opening statement.
James, anything else to add? Okay.
No, not on that.
Good. Any other questions from anyone else? Amazing. Well done. So let's push on for now, and then we will then have more time for a discussion at the end of the entire demo. So what I'm going to do.
Oh, excuse me, I'm so sorry.
Yes.
I just had one question.
Yes.
Okay. So in furtherance of the question that was just asked by Aishwarya, from the mediator's perspective, if there's a proposal that is put forth on the table, which is not within the ambit of the councils to settle on, and that proposal happens to be pertinent to the agenda that has been set. So do we drop the agenda right there and decide on discussing it in the next session, or how exactly do we go about it?
Jessica, is this a competition question again?
I think usually when there is an agenda, there's always going to be a couple of things on the agenda. It won't just be one item on any mediation agenda. So if you feel like you need further clarification from your client in terms of your limits to authority, then obviously the only way to move forward in your mediation session will be to move on to all the other items on your agenda. And I'm sure the rest of my learned friends would actually agree with me on this.
So Rajesh, let me speak from the perspective of an assessor as well as a real mediator. I think from the perspective of an assessor, in whether you are playing mediator or counsel, likelihood is in the course of your preparation, you have done some guess, right? Some assessment on what are the key issues and what are the key issues that the other side is going to bring up. If during the course of the mediation, you find that your assessment seems wrong, there are new issues being brought up, which you don't seem to have mandate or directions on, what do you do? And the answer is simply let's carry on. Either, and I have not seen whatever role play that you are going to be playing, right? Either there is an inject in the scenario, which is deliberate and is created so that you think of how to deal with an issue that you haven't seen but is relevant to the other side, or maybe somebody is making it up. Whatever is the case, how you react to it is something that assessors are looking out for, and you push on. It's true in a real mediation as well. I would love it if everybody was very, very transparent with me. I think if I always had Sharon and James as my counsels, the case statements would always contain all the key information. But more often than not, I think they as counsels have also seen that some of the case statements have important omissions of details which only surface during the mediation. And we have to cruise along with it. We have to make an on-the-spot assessment of, do I need to discuss this in order to get a settlement? And that therein is your skill. Do you know how to distinguish between a real issue and a red herring issue? Is this something being injected just to distract you and sideline the mediation, or is this something that is really key? So you've got to make the on-the-spot assessment on that.
So just to quickly add on to what Aloysius has shared is, I mean, sometimes we do want to move on to the with the mediation. So we feel like we would agree to a deal that is actually with what we think is the best for our clients, but actually it's outside of our authority to settle. So in such cases, I would recommend that you don't actually settle, because you don't have the authority, and penalties have been imposed before on participants for acting outside of their authority to settle.
And in a real mediation, please don't settle outside of your authority too.
All right, thank you.
Great. Lily, it can be explored any part, whether, I mean, again, it depends on the skill of of the mediator or the counsel. I mean, if the counsel is prepared, if the mediator is prepared to explore it in joint session, it can be explored in joint session. If mediator feels it's more comfortable to be done in private, then yeah. And I know many people will say, let's just do it in the private session so that we save face, or it's not so sensitive. I don't think there's a right or wrong to that. Yeah. Any other questions? Otherwise, we push on. Okay. Sharon.
Yes, thank you, Mr. Mediator. I would just like to keep it short, but to add on to the background facts that James, my learned friend, has put forth. Clearly, he has omitted all the tremendous effort and time my client had synced in to grow the company. It was my client's drive that led to the successful development of an investment algorithm. And this led to enhancement in terms of Red Oak's standing in the private equity market, as well as Red Oak's investment returns. My client was the brainchild behind it. I don't think James' client will be able to deny that. And, and apart from that, he has also traveled extensively to meet the main clients of the company. It was tiring, but my client never complained about it because all this was in part in growing the company and doing his part to keep the clients happy. Yet there was this particular client which James raised in his opening statement. Just to give a bit of context, he was the classmate of the CEO, which was James' client. And he always has special treatment just because he was the classmate of the CEO. And whenever there was a delay in the top up, he was given the leeway to give to delay in the top up, and not on the basis that he had no funds. He had money, but he was just a habitual thing, And this has led to a bad precedent for other clients that he brought in, because they think that they could follow his footsteps and adopt the same methodology of payment, which cannot be the case. This is against the interest of the company. Hence, my client had instructed me to send a letter of demand to put forth that position. And in particular, what's worse was we have been working together. My clients have been working together with the CEO for the longest time. He chose to raise this at the senior management meeting and publicly queried my client's decision to terminate this particular account. So my client was not comfortable with that. In fact, he felt that he was embarrassed at the meeting. And he is not comfortable with being part of a company that leverage on special relationship. In fact, there was this particular statement that my client wished for me to read out to Mr. Mediator. And if I may have the permission to read out what my clients want me to say, and I shall not change the wordings as stated by my client in his statement to me. I'm horrified by the extent of misconduct I'm uncovering. There are so many secret arrangements and deals that A has made with clients, and now he wants me to rubber stamp all of them. His own involvement is not revealed in many of these documents. The sly fox. If anything goes wrong, I'm sure he will throw me under the bus. I'm no fool. It has been my genius and hard work that make Red Oak big. If he wants to continue to benefit from my involvement, it has to be on my terms. Otherwise, he should let me out, or I will reveal all his misdeeds to the world in court. So that's exactly what my clients wanted me to say. I'm sorry it didn't sound very nice, very pleasant, but I have to say it because it's something that my clients want me to say. And well, I mean, since party A had called for the mediation, my client agreed to oblige to it. And we would like to discuss at this mediation, what is the future working relationship between the parties in order to move this negotiation forward. Prior to that, there were no talks between the parties. In fact, they have not been talking. This is what I understand from my clients.
Thank you. Is there anything else before I also make sure that I've caught most of the key points that you've raised?
That's all. That's all I have to say at this moment.
Okay, so again, before we go into a full discussion, James, if you give me a bit of patience, let me just make sure that I've heard everything correctly. Sharon, again, if there is anything which differs from what you were trying to convey to me, please do let me know and clarify. So certainly from your client's perspective, as you had shared, your client had played a very, very big part in building the company up. It's about using the algorithm which he developed, and all his work to travel to bring in business, and with all these actions and creations, your client's view is that he has helped to grow the company's revenue and market standing. The reason why your client terminated the relationship with the company's client was because the company's client was someone who had been habitually late in providing top-ups that were required to his account. And this had led to a precedent being set, which some of the clients which he wanted to bring, or that he had brought in, wanted to follow as well. And so the actual loss to the company is larger than just his own late top-ups. And really what your client wanted to do was, he believed that it would be in the company's best interest for this types of exceptional leeways to be stopped. And that's why the relationship was terminated. Where it became uncomfortable for your client was that if he felt that if there was disagreement from the CEO on the termination, it could have been done better than to have had it raised at a senior management meeting, which caused your client some embarrassment, I guess, when it was raised there. And yes, I think the statement that you were sharing on behalf of your client, I think it shows his sentiments about some of the arrangements that he thinks the CEO has with particular clients. And I think what you shared again at the end of the opening statement was particularly enlightening, because in your words, what your client is interested to achieve from this mediation is clarity on what the future working relationship is going to be like. And that is probably the priority that your client has for this mediation. Is there anything that I have missed, or I didn't give enough emphasis on?
Thank you, Aloysius. I think you have succinctly summarized my client's concerns.
Great. So at this juncture, James, is there any questions, any comments that you would like to make?
I don't think that I have any comments at this point, other than to say that there seems to be one of the issues that we might discuss more is about interpersonal relationships between party B and generally any director and the clients. I think that to me, what comes through from what Learned Counsel has just said is that there may be different ways of thinking about that.
Thank you. And that is a good way for us to go into the next part of this mediation, which is really let us try to flesh out exactly what we want to achieve for today. And you have neatly framed it there as relationships, but as you have also explained, there's actually two parts of this. One is how the company should be interfacing with clients, and the other part is the internal dynamics, right? The decision making within the company, which is something that we want to achieve for today as well. I can see these two matters. One is client management, two, the internal working relationship or the internal decision making process. Is there anything else that your client would really like resolved?
I think, well, my client would probably be able to put this better in his own words, but I think one thing that is of concern about the situation is it's really about loyalty and trust. So my client has put a lot of trust in this promising young associate, with reason. There was good reason to believe in this associate right at the start. But now it feels that the trust has broken down and the relationship has broken down. So I think that goes beyond sort of the more structural questions about interfacing internally and interfacing with clients.
Yes, I think we all hear this element of trust as really one of the main things which we want to be able to restore for everybody, and certainly I think as we work through the details of how to manage clients, how to get internal discussions going, hopefully that will provide some comfort to your clients, and I think that is something we will work hard towards. I think mediation itself is very much a trust building process. Sharon, is there anything of concern that you think we should definitely try and put meat to during this mediation as a settlement term?
I think there's also an issue of approval authority, sharing of approval authority, because at this juncture, I think my learned friend has touched on the point on not getting the management's approval over clients' related decision. If there is a point of concern and if they still wish to work with each other and stay on as the CEO of the company, this is something that has to be worked out between the parties, because it cannot be a case where the DCEO has no authority to decide on clients related matter. Surely that authority must be shared, and we would like to discuss this issue of approval.
And again, well noted. So let's also make sure that we get quite a bit of clarity on what each role can do, what B can do as deputy CEO, what does he need to turn to the board for, and what the CEO can do, and what he should also check in with the rest of the team to do. Right? I again good point. So I think we've got a pretty good agenda, and what I am just going to I'm going to state the obvious, which is that I'm actually quite pleased, because at least on this agenda, it seems clear that for a start, our focus is to find a way for both your clients to continue working together, and it seems like that certainly is the priority and preference. Is not working together also something which your clients are looking at? Is this something which we should think about discussing at this juncture, or let's try focusing on working out how they can work together first?
I'd like to try and focus on how they might work together first. I'm quite pleased that this mediation has gone the way it has so far, based on the legal letter that we received. I imagined it might go differently. But at this point, I understand that my learned friend has suggested that there might be a possibility for the parties to continue to work together. So I think we should maybe move forward on the assumption that's at least possible. And then if we need to scale back and reconsider other options, we can.
Great. And Sharon, I see you nodding as well. So let's take it that we can push ahead with this way of getting the matter resolved. In which case, what should we discuss first? Client management, approval authority, and internal decision making. I'm looking at the tree, and I'm thinking perhaps it might be easier for us to and definitely they are all interrelated, right? I mean, shall we look first at this particular client? Maybe give me a bit of a sensing. I have understood from Sharon the reasons why this client's relationship with the company was terminated. Again, James, you had explained that this client's relationship to your client's view shouldn't have been terminated, because he brought a lot of money to the company, notwithstanding that he was sometimes late. The whatever late payments, the loss and loss that would have suffered in your, as you had explained, is far outweighed by the gains he has helped the company to put in. But what is your client? I mean, is there some clarity as to how such clients should be managed? How should late payments be managed in the company from your late top-ups from your client's perspective?
I think there should be a clear process in place for potentially collecting interest. But I want to make a bigger point that's very important to my client, which is about relations. I guess this goes back to trust. So my client really values loyalty and relations, long-standing relations. And so I think I'll have to speak to my client, but I think there would be concern if there were too rigid a single formula for every single client. I think in this case, we're talking about, as you said, Mr. Mediator, a key client, a client that actually led to business from other CEOs of state-owned enterprises in China. And so, of course, maintaining staying within legal bounds, I think it's important also to have a certain flexibility. It seems to my client that Party B rushed to judgment over this particular relationship, perhaps without appreciating the full value that this particular client brings to the company.
Right. So to be clear, so that we all understand what your client is thinking about how late payments should be managed. What you're saying is that, yes, well, there should probably be a rule where a certain amount of interest is charged, and basically your client's agreement that it shouldn't be allowed as a default. That is not the default rule. But before any of these decisions are made, be it to charge interest, or as in the case of this client, for the relationship to be terminated, there should be some factors taken into account. This should not be a strict liability kind of situation. There should be flexibility to the rule, and some of the factors that are very important to your client that your client feels should be taken into account is how loyal this client has been to the company. What is the good that this client has done, and then see if this client deserves some exceptions. And certainly to assess all these factors and come to a decision, it should not be something which any singular person in the company should have full discretion of. That is essentially what your client is proposing. Is that right?
Yeah, I fully agree with that. I think it's not too different from other industries. It's simply that certain clients are more valuable to a firm than other clients. And so in relationships and contracts, the terms tend to vary from one to the next. So it seems to us that there needs to be account needs to be taken for the importance of the client to the firm, and also how much revenue the client is bringing to the firm, and then the assessment needs to make on that basis. But I think that opens the door to closer collaboration if we can reach an agreement today between the directors, between the CEO, my client, and the deputy CEO, to coordinate and to tune their violins, so to speak, about what kind of a relationship they imagine for different clients.
Great. So really this acknowledgement of the client's contribution, and not just looking at the fact that there was a late payment, but we should look at the client's record with the company holistically before coming to any determinate assessment. Right. So Sharon, have you heard from your client what he thinks should be the correct approach? I mean, and also I'm interested in your views about what James has just outlined.
Actually, that's precisely the point that my client's against having such special exceptions, because he felt that relationships should not be built on contracts should not be built on special relationships. Contracts should be documented clearly. So the company should be transparent to all clients of the company. It's not just particular client. that receive special favors or special leverage because of the relationship with the CEO. So that's my client's concern, that all these special favors were undocumented and is given on an ad hoc basis. Whereas unlike what James has put it, it was actually, that particular client was actually a habitual recalcitrant client who makes late payment every other day. So it's one of those clients that made use of his relationship with the CEO to make the late payment. So that's why my client felt very uncomfortable with all these special relationships when they are not documented anywhere in the contract that they are allowed to default on their payment with special payment of late interest as such, what James had proposed earlier. And this is also accountability to other clients of the firm, because they would think that why is this particular client receiving a special favor just because his portfolio is larger? That cannot be right. And I think we need to establish, my clients want to establish a company that has credibility and not some company that's working based on relationship. That is against his principle.
So if I'm hearing you correctly, if all of us are hearing you correctly, what your client feels is that, I mean, everybody should be treated the same. This is the way to make sure that the company is fair to every client. That there should not be special treatment given to anybody. I mean, be it, especially, I mean, and I know you've said this at the opening statement, and I hear you suggesting it again, that in this case because there was a historical relationship with the CEO that's from your client's perspective had too much weight in the decision to give him so much leeway in the late payments. But what you had said earlier, as in right now, is also that even if this client has had a larger portfolio than other clients, that should not be a factor that allows for special treatment. It should just basically, there should be one treatment, and this ensures that the company is accountable to all the clients, not just favoring a particular one. Is that what you think your client wants?
Yes, it's also accountability to the shareholders, and also as a director of the company, my clients owes a fiduciary duty to make sure that whatever decision is made in the interest of the company. So on that part, he felt that he was kind of oppressed. We call it minority oppression in legal terms, in agreeing to such special favors when the company should have been transparent with all the other clients.
Right. Okay. Thank you for that. James, any thoughts hearing this from Sharon?
Sure. Yeah. I think two things that we have in common. One is a concern about transparency and staying on the right side of the law. I couldn't agree more to that point. The other point's about documentation. We also agree that there should be all the appropriate documentation to avoid legal problems, of course. But I feel that we failed to see eye to eye about this issue of whether special treatment can be given to one client or another. And I guess from my client's perspective, it's just a matter, it's just a commercial matter. Some clients are more valuable than others, and so they will get different terms in their private contracts with the company. That doesn't mean that it's meant to push the law. It's just a commercial fact. Some clients are more valuable than others. And a client like this, which has historically brought so much business to the private equity firm and so many clients to the private equity firm, to be overly concerned about what represents really a small percentage of the contribution of that client it seems to us to be not a very commercial way of thinking. However, to re-stress the points that we have in common, we agree that we need to be very transparent and we need to have all the appropriate documentation.
Okay. So, I mean, writing on the transparent point, perhaps we could suggest that before making any special exceptions to the client, can that approval be shared between your client and my client, such that both parties are aware that such special approval be given to particular client A? So we are on, my clients and your clients will be on the same board, on board to the same thing. Yeah.
Yeah, thank you for the proposal. I think it's a great idea to involve not just one person. Maybe it could actually be a decision taken by the board of directors more generally, because it may simply be that my client and your client have different expectations, and then by bringing all of the executives' opinions to bear, we actually might be able to reach a clear consensus that reflects what the shareholders would want. How do you feel about that?
That's an excellent suggestion, James. I think this would be something that will rest well with my clients, because so long as notice is given, approval is obtained, which includes, I mean, since they are part of the senior management, naturally, if you bring this up at the management meeting, they would have the opportunity to either vote for it or against it.
And I think we're making excellent progress on this point. You know, and again, thank you both of you for being constructive in this, right? And James, thanks for highlighting that there is actually quite a lot of commonalities in terms of both seeking transparency. It is I think what we have agreed now is really that look, then in the spirit of transparency, if there were to be exceptions to be made, this should be surfaced. We should be specific about what these exceptions are, and this should be a decision that the endorsement, the prior endorsement of the board, is obtained first, right? So and I think this is good progress. There are definitely still details to be worked out. I think if we can achieve this principle right now, this is great. I mean, it's and it is important for us, perhaps by the end of the mediation, to think through as well, you know, whether this is something which is going to apply to all clients or to clients above a certain portfolio, and what is the nature of the approval that has to be obtained to proceed. Is it a majority vote, or is this a different level of approval? But I like the fact very much that, you know, we have come very quickly to an agreement on the principle we will work on in terms of managing the clients. Because that, like I said, given the issues that we have to discuss, it is in a way we've already covered as well decision making, you know, in relation to how to manage clients when they default on payment. If the devil is in the details, and it is this element of approval authority. When is this something which either the deputy CEO can make a decision on? When is this something that he needs to surface to the rest of the management? When is this something that needs to be surfaced to the whole board? Is this something which, well, actually my thinking now, looking at the background of the case, is that it might be useful for me to meet with each of you privately, because I've seen from the case statement that you've both given me that there might be some sensitivity in the details of this, and probably good if we can meet privately to discuss this. Is this something which the both of you agree on?
Yes, absolutely.
Yes, sure.
Thank you.
Great. So the way I manage private sessions is that everything you tell me is going to be confidential until you give me permission to share. And there is no hard and fast rule about who can meet me first. Just like the opening statement, there was no hard and fast rule about who can speak first. But in this particular instance, if both sides are agreeable to it, I probably would like to meet with Sharon first, and hear from her what her client would like in terms of his approval authority. Is that going to be okay with you, James?
Indeed, yes. Thank
Wonderful.
you for asking.
Wonderful. So James, how we will do this, because we're doing it via Zoom, do use this time to take a break, but please don't go too far from your computer. I assume I won't take very long with Sharon. Typically, I guess if you can come back after about 10 minutes, I think that will be useful, right? I might not be done by then, but it wouldn't be too long after that. So use the time as well to if you need to check in with your client about what had happened, and let's think through what is it that we can do to continue to progress the mediation, which has been making very, very good progress, thanks to the both of you. All right?
Sounds good. Understood. Thank you very much.
Great. So let's stop there for a bit. James, don't run away first. Any comments? Yes, I'm sadistic that way. If I can't run away, nobody can. Anyway, so yes, Jessica. Any questions or comments from the group? Is there anything in the chat that I'm missing? Because I'm not really watching the chat closely.
Yeah, so I think we have a question from Elizabeth here. Is reaching an agreement on every single item of the agenda mandatory in the competition in real life? So I'm gonna leave you guys to answer in real life first before I answer the ones for the competition.
James?
No.
Definitely no.
No, it's not necessary to reach settlement on everything. That would be a beautiful thing if you could in every case. But a real advantage to mediation is just to narrow the scope of issues in dispute. So settlement might be able to reach on a number of issues, and that could simplify the dispute for arbitration or for litigation, or it could provide a good foundation for negotiations at a later date on the issues that are still outstanding. So no, it's not necessary to settle every single issue.
Yeah, I echo what James had said. I mean, it's in the ideal world, it may happen, but in reality, it's very, very difficult to achieve even a settlement on all terms. In fact, to even achieve a settlement itself is a miracle. So that itself is something that parties work very hard towards to reach in a real life situation. But of course, we try to narrow down the issues in anticipation that this will pave the way for further negotiations after the mediation. Sometimes we do settle after the mediation, but at the very least, narrow down the issues.
So I have been outvoted 2-1 because my answer would have been yes. But then I'm a mediator, right? I mean, so certainly, look, if you're a mediator, there is this commitment which I feel we give to the parties that we'll work hard with them to try and get all matters properly resolved by the end of the mediation. But I think where I agree with Sharon and James is that number one, let's be sensible and wise in filtering through all the issues that are surfaced during the mediation. I keep saying that it is extremely common that there are red herring issues, and you're not expected to convert from being a mediator to a marriage therapist or a company coach or things like that. So you cannot make a company make money from 1 day or 2 day mediation. Some things you can't resolve, but for the purpose of the mediation, whatever's relevant to the dispute, if you're a mediator, you should persevere and try and get the matter resolved. Again, then where I agree with Sharon and James is that even if you don't manage to settle everything that day, you don't need to go away dismal and blame your mediation trainers and yourself for not having done a good job. Because there are many things which you need the right time to achieve settlement on. And there are many mediations where you've helped a lot to narrow the gap, given them the parties food for thought, and then you let the parties negotiate the rest on their own. Sometimes if you're lucky, the parties come back and tell you that they closed it on their own and they thank you for it. Other times you just have to live in the comfort of knowing you've done your very best for it. But don't kill yourself just because there is no settlement. Unless of course you really did a bad job and you made things worse for them. Then don't kill yourself either, but for me, the simple rule is that you have done well enough as long as you didn't make things worse. I saw somebody flash in and out. I'm assuming that the person had something to say.
So thank you to my panel. I'm going to agree with Sharon and James in terms of the competition. So if you refer to the rules and guidelines that have been circulated, the annexes actually tell you what the competition rubric is, and reaching an agreement on every single item of the agenda is actually not on the criteria. So you won't be marked down if you don't actually reach a settlement on every item on the agenda. What you will be actually be assessed on is actually the process. So yes, clarity. So basically the rubric that has been circulated to all participants in the rules and guidelines is the exact same thing that judges will be using for scoring during the competition rounds. There won't be any extra sort of like a criteria that you don't know about. And we've already told our judges not to sort of like put a spin or their own influence into the rubrics as well.
If I can take Anchal's question in the chat, because I build up on what we have just explained, right? I think, again, it's part of your mediator's skill. If you can see the relationship between the different issues and so transit your discussion of each issue smoothly, because there is definitely a relationship. The issues are coming up relating to the same dispute. So your part of your skill is seeing the relationship and knowing how to transit. You are not, I think in this particular demo, councils are being helpful in that they've kind of created a principle, right? But of how to agree on the first and second issue. But you are not expected to do that in live or in the assessment. At least at this juncture, all that I had hoped to do, but I went beyond that, or rather parties helped me to go beyond that. All I had to do was to concretize where does each party stand on that particular issue. At least, even if I cannot get them to agree, I get them to agree on where they each disagree. And I think that is where you want to end at the discussion during the agenda. Was there any other written thing?
Yeah, so we have one from Naoshin. In this competition, are mediators allowed to suggest options or solutions, and will these be marked negatively? So I think the panel is going to agree with me on this. There are many different types of mediation styles. You have evaluative, transformative, facilitative. You actually won't be marked down on whichever style you pick for your own session. In terms of being marked negatively, this particular criteria is actually not on the rules and guidelines, so it's not in the rubric. So I suggest that participants do actually familiarize yourself with the competition rubric. So there is different rubrics for mediation advocates and different rubrics for mediators. So do familiarize yourself with those, and whatever criteria that's not on there, you will not be marked negatively. So basically, that you shouldn't be marked at all if something is not there.
Sharon, James, what do you guys think in real life about mediators proposing solutions to your clients or to you during the mediation?
For myself, I mean, it depends on the client. Some clients actually require an evaluative mediator rather than a facilitative one. They would like to hear from the mediator, because especially if the mediator has some background, especially judiciary background, they have decided similar cases before. They would like to hear from the judge what is likely to happen if the case were to be, if they were to push on with their case. So there are cases where we ask for evaluative mediation. And depending also on the competency of the client, some clients are very competent. They have in-house counsels on both sides. They rather have a facilitative one, which just facilitate the negotiations between the parties.
James?
I hate to be so agreeable, but I fully agree again. I think from my perspective, it's an important thing that might be brought up at an early point with the parties to get a sense for their expectation, because as was pointed out, it may be that the clients really expect some level of evaluation. And I think it's good to be clear about that right at the start when the mediator first meets with the clients, either by describing their own style and asking if clients would prefer some variation, or by simply asking point blank what the clients are expecting in the mediation. But one point I will stress is that the line's not always so clear, of course, between facilitating and evaluating. And it could simply be that by asking challenging questions, you are actually evaluating, but it's the communication is of a different nature. But at the same time, there is an evaluative feature of that. So I think that the categories sometimes they blend.
Thank you for both your answers. I mean, I'm going to push a little bit harder here, because at least in this part of the world, and I know we're not alone in Singapore, there are many mediators who feel strongly against evaluative mediation. They are afraid. I think like exactly the scenario that Sharon has painted, right? When the mediator has historically has judicial experience, you know, and we know that he or she is going to draw on his past experience to give his assessment of the merits of the case. Number one, it might parties feel, you know, that it's the mediator is biased. Number two, from the outset, knowing that the mediator is going to give this assessment, that the party will come in with an adversarial mindset, will come in with a mindset of, you know, I need to persuade the mediator to be on my side. What do the two of you think about this arguments against evaluative mediation?
I think from my perspective, the mediator is offering a service, and the service should correspond with what the parties want, which to me highlights the importance of having a conversation early about the parties' expectations. And if the parties want evaluation, then I think if the mediator is uncomfortable evaluating, they can say so and they can find another mediator. But I think that there needs to be clarity and transparency early on so that the service offered is the service that the parties are seeking.
Thank you. Sharon?
Yes. In fact, during the pre-mediation stage, the pre-mediation conference will be useful to find out what exactly parties expect out of the mediation. I mean, as with most complex mediation, usually there will be a pre-mediation session where parties have a chance to speak to the mediator, and the mediator will elicit what parties expect out of this mediation and his role in the mediation.
Thank you. So let me answer my own questions a little bit, right? There is a growing demand for evaluative mediation, even in Singapore. And I agree with Sharon and James. If ever people come to me to ask me for evaluative mediation, and they have, this is something which I clarify and make clear that everyone is agreeable to it, and that then during the mediation, do not be surprised if there is evaluative behavior. So that is one aspect that we need to make sure that we have everyone's buy-in. You don't be appointed to be facilitative and then surprise them by telling them that, hey, you know, actually you have a very bad case, you know that, right? So that is one thing to do. The second thing to do is this arguments about, you know, does this color the party's behavior? And this is something which, again, relevant for competition and relevant in real life, but perhaps more so for the competition. One thing which I noticed about advocates is that some of the skillful advocates start to bypass the mediator completely because you guys want to show off your negotiation skills. But this is a mediation competition, and how you work with the mediator to get a good outcome for your client helps. This is not a negotiation competition, right? And in real life, even for facilitative mediation, I often tell a lot of mediation advocates, what do you think you are trying to do? Are you trying to preserve the mediator's neutrality? You are not. You are trying to persuade the mediator that your client is behaving rationally so that the mediator will help your client to get a good deal, even from a facilitative role, right? So as an advocate, you should always be trying to persuade the mediator and engage with the mediator. And I think that's part of the scoring, whether you know how to use the mediation process and the mediator. Great. Anything else in the chat that I'm missing? Is there anyone that wants to?
From Adrian, actually.
Hmm.
So are there instances of where there is an impasse and the mediation ends with no resolution? Parties are prepared to go away to reconsider and reconvene later for follow-up mediation.
All the time, and Sharon has counseled. Okay, no. I'm kidding.
Are you saying I'm the difficult one?
Yes, Adrian, that's very, very often happens. And again, this is the skill of the mediator, right? That you stay the cheerleader and you stay positive, even when the result looks negative to everyone. You cheerlead and tell them, look, I'm sorry, it's now 5 a.m. But I see that we're all tired and we're still not anywhere close to a mediation. I typically don't keep people till 5 a.m., though there are some who do. But generally, if you know that parties are tired, it's time to close, we're not near to it, you still say, but actually we've made a lot of progress on this and this and this items. And we've narrowed the gap significantly. I think we are on the right trajectory. It would be good for all of us to get some rest, think through the issues, rather than feel ourselves pressured to narrow the gap out of fatigue. And I assure you, I will always be available. I mean, I'm sorry that at least with my involvement today, to this point, we've not totally wrapped up all the matters. But I think if we had a bit more time and a bit more rest, certainly we will continue to make progress. And I'm always available to help you to make that progress if you want to use me. So you as a mediator then need to do that cheerleading and proper wrapping up. Sorry, Sharon, you were going to say something as well. Yeah.
I just want to clarify, I wasn't the one who made you stay till 5 a.m.
Yes.
It's just 12 midnight. It's not 5 a.m. And that's due to time difference. Actually, one thing about mediation is that when it involves international parties, it's quite common that we have to wait for the US in-house counsel to wake up, and that actually drag on the mediation to weird hours. But otherwise, I mean, parties were generally quite cooperative, and so far we had a pleasant experience with Aloysius. I won't complain about him openly in.
Thank you, Sharon. You're very kind. Not that there was anything to complain about, but again, I think as Sam has said this, for real life, because so much is happening over Zoom these days, Zoom doesn't respect time differences. So when I mediate over Zoom for parties from different jurisdictions, finding that compatible time zone is necessary. It's also very challenging. Yeah. Any other questions, comments?
Not for now. I think
Okay.
we're good to move on to a private session.
Yeah. So we just do about 5-10 minutes of one private session, and then let's come back to a group discussion. Okay. So I just want everyone to have a chance to see how a private session might look. Great. So I'm going to meet with Sharon privately. Yeah. So James, you can stop your video and yeah. Right. Sharon, again, before we start the private session, just want to say thank you for having really been very, very constructive in the earlier discussions. And before you say anything, want to again stress that everything that you tell me during the private session is going to be confidential, right? So we are trying to go into greater depth on the approval authority for your clients. And I guess for other colleagues in the company as well. You want to let me know what are some of the thoughts your client has, and as well as with any other thing which you might not have been comfortable sharing earlier. Yeah.
Thank you, Aloysius. I mean, my clients wanted to impress upon the other party that he has invested a lot of time and effort in building up the firm. So to be honest, I mean, this is something that we cannot say during the open session, was that he's not sure if he could find another boss that will be as equally supportive as the current CEO. Yeah. So hence, I mean, if my clients were to continue as the deputy CEO and the director of Red Oak, what he wanted is to have transparency in the decision-making process and to get things right. I think in our earlier letter of demand, we previously requested to see the financial statement. I think that is something that would give my clients a lot of confidence to ensure that Red Oak is a credible organization. And second point would be the sharing of approval over decisions of the firm in investing and clients related decisions.
So again, thank you for confiding this matters to me, and I'm glad to hear that your client recognizes that the CEO has been really appreciative and quick to recognize and trust your client with the company. You want to give me a bit more details about these matters, that how clients decisions over investments and decisions over the clients should best be handled from your client's perspective. I mean, I take it that yes, things should go to the board and all that, right? And you weren't objecting to these matters earlier, but
So basically, my clients only had like a simple request that he must have notice of these special exceptions that were granted to certain clients that are of like certain value to the firm, that are important to the firm. He recognized that there are certain clients who have like larger investment portfolios. So if the firm wishes to grant special exceptions to these clients, it must be done with his notice and approval. That is the requirement. So that's where we are talking about the sharing of approval authority over clients' related decision.
how large is large to your client's view? I understand that this particular client from the case statement had about $50 million with your company. Is that considered a large amount? Because in this instance, as I know it, your client made a unilateral decision to end the relationship. So $50 million still wasn't considered large to your client?
It wasn't about that, but he was more concerned about the shady deals that the CEO entered into with this particular client, in granting him certain leeway in making the late delay payments and causing loss to the company, you see, because as a result of that particular client's action, the other clients that followed suit caused an estimated loss of about 15 million to the company. So as a collective loss, we are estimating it at 15 million. It's not just one-off transaction which caused the loss.
So this is interesting to me, because then what I gather that you are trying to say is that from your client's perspective, if as a deputy CEO he notices that there is grave harm being done to the company, then he should have unilateral power to quickly put a stop to it, rather than to have to go through the process of trying to seek approval from the board and all, because the idea is I want to stop the harm, and further delay might actually cause greater harm. Is that what you're saying?
Yes, in fact, the reason why he asked us to issue a letter of demand, because he felt that his concerns were serious and he wanted to let the CEO know about it, how serious he was in all these shady deals that could implicate the firm. And and as such, he has suggested having a joint approval authority, because if that joint approval authority is not acceded to, he would rather be out of the company, and it's best to part ways, because he felt uncomfortable with that special relationship that the CEO had with certain clients.
So this is good, right? Because I think at least between the two of us, since we're both legally trained, it's your use of the word joint. Because in the situation that has led to this mediation, in a way, it was because your client decided on his own to terminate the relationship. But what you are saying seems to be a shift in this behavior. He recognizes that, well, okay, fine, even if I don't have unilateral decision-making power, I have some, but it is a joint decision-making power, and your client is going to be comfortable as long as there is an express acknowledgement that there is a joint decision-making that has to happen. The CEO cannot allow keeping this such clients and such behavior on his own. Similarly, he cannot terminate such clients on his own also. It should all be joint, both the keeping and the terminations. Is that what you are saying?
Yes. So any clients-related decision should be made jointly, especially when it comes to special exceptions, because like special exceptions for late payment to top up the funds, this has to be made jointly so that it's transparent, it's across the board. Everyone knows that this special exception was made for this particular client. And we are on board for that. And I think my clients also would like to explain, although it was not mentioned in the joint session, is that because he had to travel so much, he simply had no time to give all this detailed explanation. Not that he didn't want to give, but he didn't have all this enough time. In fact, he didn't even have time to sleep. So it's not that because he deliberately ignored the CEO's approval to obtain the CEO's approval, but because he was on a business trip, so there were some time-sensitive investment that he simply had to pause through. So it's something that he acknowledged that there was some slip out on his part in giving the explanations to the CEO.
Thank you, and this last part is really really useful, I think, because I think you've heard from James how concerned the CEO is with, James has been repeatedly using words related to trust. I mean, I think I can repeat it here. He started with words like ingratitude, and even a strong word like betrayal. And I think if we can help to clear the air and let the CEO know through James that really there was the intention was not, again in James' word, was not a mutiny. It's just that there was so many things that your client had to deal with. He didn't have the time to seek approval all the time, but on hindsight he does realize that yes, it should have been done better, and I think if you are agreeable for me to share that and to frame it in that way, and then to say that, look, really, then your client also agrees that as an express principle, decisions relating to client management should be made jointly and not unilaterally. If you agree with this framing and this position being transmitted, I think we have a good chance of making progress and getting agreement. Is that okay?
Yeah, I mean, what my clients mandate me is that first, we want transparency. We want to have some assurance. We want to see the financial statement. That's the first thing. Second, sharing of approval over clients' related decision. Any special exceptions that to be granted to the clients must be made with our clients' notice and approval. That's essentially, these are essentially
all clients. This is regardless of the portfolio, regardless of the history. All clients, because he's the deputy CEO, should be jointly agreed.
Yes.
All right. So I hear you on your client, on him being given sight of the financial statements, and I hear you on having joint decision making. Is there anything else that I should bring back?
I think the key point is there should be no special exceptions granted that without our client's approval, like in this particular case. So that's the main thing. If it cannot agree to that point, then I'm afraid we don't have a deal today, because that is something that is sticking out to my clients, and it felt very uncomfortable about that.
Yeah, well, I don't want to give you any false hopes, but again, given the progress that we achieved earlier and what James had said earlier, I do think that this all that you have shared with me there's reason for some level of optimism, right? But maybe let me then spend a few minutes with James. I think this conversation with you has been really, really useful. You take a quick break as well. Same thing as I told James earlier. Don't go too far from your computer. As you can see, the private session doesn't take very long. And let me check in with James very quickly with some of the things you have shared with me. And then let me come back and update you with what he has to say about it.
Sure.
All right. And if same thing during the break, if you think it's necessary to update B and take more instructions from him, do so, and let me know if you need more time with him. Okay.
Sure.
Thank you. I'll see you soon. Okay, let's stop the demo there. Let's go back to for those who are comfortable showing me who you are, feel free to open your video. Those of you who are shy, you've not done the makeover for the competition yet, it's okay. Yes, and any comments or questions or anything that you guys want to ask, this is the time to ask what do assessors want to receive to give you all full marks and help you all to win. I think James is asking for business class air tickets, which are not useful, so maybe just a private jet. Sharon is fitter. She says a kayak will do. Any questions or comments? Should the counsels in their opening statements and also throughout the session use harsh words like betrayal, breach of trust, etc., or is it marked down or taken as being negative or stubborn? Sharon?
For me, right, I'll try to avoid toxic words at the beginning because that actually might set a tone of the mediation on the wrong footing if you start with very strong words. Your clients may have said that to you, but you should rephrase it and try to make it sound more neutral, but yet at the same time convey your client's interest without compromising it. It's easier said than done. But I mean, that is the whole gist of the mediation process, which is to move parties towards an amicable resolution, right? So if the tone is not right, it's quite hard to move forward.
James?
I can't speak to the competition. I don't know the competition rules, if the students would be marked down, but I tend to agree. I tend to agree that words are very important, and by using a very toxic word, it can set the wrong tone, and that can set things going in the wrong direction. As counsel, though, you might have a client who has very strong feelings and who wants those feelings to be expressed. And so then it's just a question of trying to find the right words that aren't too inflammatory, but that also make it very clear that your client has a particular emotion.
And I've got nothing more to add to that.
So yes, words are very important, like what Sharon and James has shared. In terms of the competition rubric, again, please check the annexes of the rules and guidelines, what will be marked, and well, what you will be scored on is going to be in your annexes, and the use of harsh words, it's not on the rubric.
Any other question? Comments? Everyone is very happy.
Yes, I have one question, Alois.
Yes.
At the risk of sounding repetitive, I just want more clarification on this. So I'll just ask this again. I understand that there are multiple ways of carrying out the mediation from the perspective of a mediator. He can take up the role as a facilitator, or he can take up the role as an evaluator. So facilitator is given, that is like the general expectation of the parties. But with respect to the evaluative role being taken by the mediator, let's say, is there a way that we can define the limit of to what extent can the mediator be evaluator, so that it doesn't appear that he is trying to mar in the interest of the parties, or trying to act prejudicial to their interests. If I may just give a example, a very small example for clarity. Let's say there's a proposal that has been brought forth by party A, which requires, let's say, neutrality from the side of both the parties. However, party B does not have like a express input in that, but the mediator understands that for the purpose of neutrality in that proposal, it's important that party B also gives their input. However, that is not coming. So can that be something which can be addressed by the mediator directly?
Let me speak from my view again as the assessor first. I certainly will look very cautiously. You open up yourself for greater inspection if you start proposing solutions very early, right? Then certainly from my role as an assessor, there's a question mark in my head about does this person know the difference between a mediator and a neutral evaluator? And I think this perspective that I have is particularly because I have actually interacted with evaluative mediators, professional evaluative mediators, and even they tell me that, look, Aloysius, my parties trust my assessment because at the outset of the mediation, I spend a lot of time listening to them, building rapport with them, and not judging them, not being critical of them. And because they know that I have spent so much time at the outset listening to them uncritically, trying to find out what their deepest concerns are, that when the time arises for me to tell them my views on how the matter should be resolved, both sides or all sides are agreeable to use what I have proposed, either as is or as a reference to build an agreement. So for the purpose of the competition, you only have about an hour. And if within this very early juncture of that hour, you are already proposing solutions, I would certainly be quite curious on how this is done smoothly. If in the scenario that you have raised, that it's just one party being deliberately unhelpful, we are discussing the issue, the other side has already given quite a more meaningful outline of how to resolve the dispute, and the other side is just not forthcoming. Rather than you proposing what to do, I think you need to think through what you can do as a mediator to nudge that party along. In all likelihood, I don't know what is the true background, but my first instinct as a mediator is I'm not asking the right questions to get this party to open up. There is something more, and I need to approach this differently. And I think that should be your first port of call, rather than to immediately try and propose or pressure the party to give you the reaction that you want to receive. Sharon, James?
I agree with Aloysius in the sense that I would expect the mediator to nudge my clients to give the options instead of the mediator giving the options themselves, because if the option comes from the client, they are more willing to accept it. If it comes from a third party, they may be thinking that's not what we want out of this mediation, and it might actually turn the mediation the other way around if parties does not agree with what the mediator has suggested. So it's best for the parties themselves to come up with the suggestions.
I agree. I would simply say that I think timing is very important. I think the more time that you invest in the beginning as a mediator and asking lots of questions and understanding the positions of the parties and the interest of the parties, the more you build trust. And then when it comes to the point where it's later in the day and maybe settlement is in reach, then you can be a little more pointed with your questions. And I think then again, it's just a question. It's a matter of language. I mean, it's one thing to say, I think you should, and another thing to say, how do you think the other party would respond if, for example. So a lot of it, I think, is just phrasing, and pushing back can actually be evaluating. But if it's posed as questions just to better understand what the party is after, then I think it can be evaluative, but it's not overtly evaluative. I mean, it's difficult to do that if the mediator has a very clear idea for how to solve the problem and the parties haven't breached that. But there's a lot of margin up until that point where I think pointed questions can be asked that are evaluative, but they're not statements, they're just questions.
There's this question from Mara in the chat. In the simulation, the fact-finding process was mainly done through the mediator. In practice, would it be wise for the mediator to let it happen through a direct conversation between the parties? So in practice and in the competition, I would always encourage the mediator to take on a more active role. Again, because for the purpose of the competition, like I said, this is a mediation competition. It's not a negotiation competition. For the purpose of practice, real cases, if you leave it to the counsel, the reality is that they have hired you because they couldn't resolve it by talking directly at each other themselves. Most people try to negotiate and settle the dispute before they turn to a mediator, right? So I mean, this is something which, that's why I always ask counsel in my pre-mediation, what happened between your negotiations earlier that led to you deciding you can't do this yourself, and you've got to get me, because look, you guys are great negotiators. Sharon is an amazing negotiator, and so is James, but from time to time they still engage me as a mediator. What was it that you want me to do that you can't do on your own? So if you come in for the mediation and you say, okay, you guys talk, I'm just here to listen, and I will gather information from that, chances are you are opening the door to a slippery slope downwards, right? So you need to come in early to try and rebuild that positive momentum, rather than let it be a direct conversation from the start. Later on in the mediation, when you have created enough of that positive momentum, you want to let the parties talk among themselves to get the matter resolved, as had happened during this simulation. Sure, but at the outset, no, I would put myself in between them. Yep. From Vasiliki, would it be better to explore the agenda topics one by one, or would you suggest exploring the dispute as a whole and then negotiating on each topic of the agenda separately? I think that is why we set an agenda, in the sense of, look, it is one dispute, but we do need to be organized in the way we address the dispute. So we are when we set up an agenda, it is basically to deconstruct the dispute, break it down into chunks that we can manage, and then go through this issues systematically. As my professor likes to say, the agenda is a roadmap. And the issues are basically milestones that we need to achieve to complete resolving the entire dispute. Which milestone should come first is your mediation skill and strategy. Some people like to do the trickiest one first, and then the rest of it just falls in place. Others like to do the simplest and create momentum. There is no right or wrong. You judge what is the better strategy based on the parties before you and the dispute before you. Happy for Sharon and James to disagree. Yeah.
I can't disagree. I'll make a very obvious point, because I'm sure that the students have already covered this ground, but also language is important with respect to the agenda setting. So it's very important to use neutral language when identifying the points that the parties want to cover. So something like betrayal would not be an appropriate issue. It might be relationship or something more neutral.
Yes, and also it's a question of strategy. Like sometimes you want to build on the momentum. You feel that as a mediator, you feel that it is better to get parties to agree on some of the easier agenda items, so that parties will have more incentive to move the negotiation forward and deal with the difficult one. So it actually depends very much on the momentum of the mediation and the parties involved at that juncture. It's a judgment call.
Okay, it's 3:52, which means that we probably have time for one or two more. Ashwaya, you have something?
Yes. First of all, this has been very helpful. Thank you. I have a question with respect to how technical we can get when we're proposing solutions. So a couple of the role plays that we've been given required a little bit of technical knowledge, building materials or networks, etc. So while proposing solutions, how technical can we get?
I think, again, applicable to both practice and competition, you need to understand the nature of the dispute that you are mediating or that you are representing in. So certainly, if you have received a case that has technicalities that you don't understand, part of your work as mediator and counsel is do the research, right, and find out what those words really mean. And then if in the process of researching, you also uncover, hey, actually there is this solution that can be used. I mean, if you are counsel, then certainly if you think that this is relevant to getting the matter resolved, why not let the mediator know that there is this way of providing a specific remedy through a technical remedy. Yeah.
All right, thank you.
Maybe I'll just add one little bit. I fully agree with that. I can't speak to the competition. I don't know the rules. But the only risk in real life is that, especially with legal issues, if as mediator you immerse yourself too much in the legal issues, you may start looking at the issue almost like an arbitrator, and you may be sort of prone toward particular solutions. And I think that's one of the reasons why in real mediations, mediators often encourage the written statements to be quite short and quite succinct, because they don't want to be overwhelmed by detail and thereby perhaps lose themselves in the parties' positions and lose sight of the potential interest of the parties.
Thank you.
I'm just going to jump in here. So in terms of the competition, some of the role plays have been drafted to be quite technical, yes. We do ask that you do, like Aloysius said, have some form of like simple research, a basic research at least. So you know what sort of solutions you can propose that's within your mandate or not within your mandate as well. In terms of having specialized knowledge, like for example, for the construction role plays, we don't necessarily expect you to sort of like be a contractor, you know, like and know what the measurements should be or that sort of thing. This is actually not what we expect out of you. Again, you're being tested on as mediation advocates and as well as mediators, not how well you can role play a specialized industry.
Any other questions? Comments? Did I miss anything in the chat at all?
No, I think well, it seems like we've covered everything.
Right.
Thank you, Aloysius, James, and Sharon. If everyone could sort of like put your hands up for everyone or something, or just thank the panel. Yay! Okay, so thank you everyone for joining us today. This session is gonna be uploaded on YouTube at the end of the post event, a couple of hours later. We will be circulating the links again for you to have a look as and when you would like. This video is gonna stay up until the end of the competition.
If I can just say one quick comment. Have lots of fun at the competition. Please don't take the educational element of it. Take the fun out of it. Don't look at it overly competitively. And have a good rest. I think that is actually the trick to performing well for the competition, as it is in real life. Right? Go and get a good rest. Stay healthy. It is a interesting year where staying healthy has its own critical emergency, right? And I do look forward to seeing all of you in Singapore and in person very, very soon. Thanks for making time today with us.
Thank you, Aloysius. And for participants, you'll be seeing more of Aloysius as well as Sharon during the competition rounds if they're going to be your judges.
We are very strict. Good luck to you.
All right. Thank you, everyone.
Okay. Thank you. Bye.